Hello everybody, it's Rick. It is the 23rd of May, 2025. Okay, so we're going to do a video today on how does the court acquire jurisdiction? How can you challenge the court's facts in issue? What are facts in issue or issues of fact? How does the state assign civil status, rights, and obligations? And how can you avoid being assigned a civil status? How to obtain my affidavits? You can contact me. Please use all of the emails below. And again, I apologize if I do not respond. It could be two reasons. I didn't get the email, which is why I ask you to send them to all of these email addresses, or I can't help you. You know, some of you have these cases where it's 15 years old. Okay, and there's this misconception that once the court doesn't have jurisdiction, it's void. It's just you have to prove these things. You just can't go into court and say, well, you don't have jurisdiction, so everything's void. You have to be able to prove it. So the easiest way to stay out of trouble is from the beginning. Okay, so that's where I have some of my best success is in the very beginning, because there's a way to avoid these things. And as I said in my past video, this is all contracts. Okay, this is all contracts. They're not going to admit it, but it is if you read the case laws and how they word things. Okay, so acquisition of jurisdiction. This is from Volume 20 of American Jurisprudence, Section 42, acquisition of jurisdiction. The general rule is the court's acquisition of jurisdiction over a case depends, and here's the important part, on the facts existing at the time its jurisdiction is invoked. Meaning, when someone walks into a court and files an action, what facts did they present to the court? And usually it's nothing. Okay, they just make a claim, especially in these scam child support courts. Okay, so we're going to have to challenge those facts. Accordingly, in a civil suit, acquisition of jurisdiction ordinarily depends on the facts existing at the time of commencement of the suit as they appear from the complaint or other pleading of the plaintiff. Okay, so what claims did the plaintiff make? Are they facts? Well, they're actually presumptions, and a presumption is not a fact. Just to answer the question from before, what is a fact in issue? A fact in issue existed at the time jurisdiction was invoked. We'll get back to that. I apologize, I screwed that one up. All right, so how does the court get jurisdiction over subject matter and jurisdiction over parties? Again, from the same American Jurisprudence section, this time section 105. Jurisdiction over subject matter and jurisdiction over parties. The conception of jurisdiction of courts is generally split up into two branches: jurisdiction over the subject matter and jurisdiction over the parties. To properly act in a case, a court must be vested with both jurisdictions. And it seems that certain presumptions apply only with regard to a judgment rendered by a court that has both jurisdiction over the subject matter and jurisdiction over the parties. So the presumption is they do have jurisdiction over both. So that means you have to object. I do not suggest objecting to subject matter, because the court's subject matter jurisdiction is a child support court. The child support court is a domestic relations court, and they're there to establish, enforce child support. So they already have that. That's what they were created for. So you can't challenge that. But what if there's no proof that you have an obligation. That's a different thing. So what you want to do is you want to try to not be a party. So again, it said it's subject matter and jurisdiction over parties. Okay? So that a court has jurisdiction over a party means either that party has appeared, there's the operative word appeared, generally and submitted to the jurisdiction. That he or she has otherwise waived service of process, or that process has properly issued and been served on him or her. Jurisdiction over the subject matter has been variously defined as referring to the nature of the cause of action, okay, child support, and of the relief sought, excuse my New York accent, the class of cases to which the particular one belongs, and the nature of the cause of action and the relief sought. The power of a court to hear and determine cases of the general class to which the parties particular one belongs, and to both the class of cases and the particular subject matter involved. So what it says here is how to not be a party. You can't appear. Appear means show up, but when you show up, what do you have to do? Well, again, if you've never been in court, this is the best time to state a special appearance. Object, special appearance. The court does not have personal jurisdiction. Okay, now if you've been in court already, you've already waived it. Okay? So, again, appearances from American jurisprudence have been classified as either general or special. An appearance is special when the defendant appears to object to the court's jurisdiction over the defendant's, what the hell did I do here? It's the defendant's person. And confines the appearance solely to that question of jurisdiction. A special appearance may not be used to challenge subject matter jurisdiction. You see that? So really what you're saying is you're challenging the personal jurisdiction. Now again, here's the thing. Person can mean many things. See, we use that word all the time. But there's different statuses of persons. The person that we're talking about is an obligor. Okay? So that's a fact and issue. What proof do they have that you're an obligor? An obligor is a status that they impose on you, and if you don't object to it, it sticks. Okay? So again, appearances from American jurisprudence. What constitutes an appearance? A party appears when he or she takes any action other than objecting to personal jurisdiction that recognizes the case is pending. Okay, how do you submit the jurisdiction? Answering questions is submitted to jurisdiction of the court. My appearance, this is an example, my appearance is special to object to the court's personal jurisdiction, and I just add that in there, refrain from answering questions or any act that could be interpreted as submitting to the jurisdiction of the court and appearing generally. So I've said it in my past videos, you just want to be polite and say, I'm sorry, I object. My appearance here is special to challenge personal jurisdiction. And I wish for it to be in writing. Because another trick they'll pull on you is they'll say, okay, well we have special jurisdiction. We have personal jurisdiction. And what they're doing there is they're making an offer to you. And what you're going to say is, well, I'm sorry, I reject that explanation. I'd rather have it in writing, so I have it on the record. Because they don't want it in writing. They do everything they can not to have things in writing. Okay? Special appearance is an objection to the court's personal jurisdiction. Just said that, okay? Person is synonymous with persona. You've heard that word before, persona. What persona really means is a mask. It's what mask do you wear in public. I've made that point in the past video. Okay? What mask you consent to wear defines your persona. Obligor is a mask they want you to wear, and they're going to impose that on you. Okay, did you consent to act in obligor persona? That's a question. Also, obligor is a fact and issue. Okay, is there evidence of a contract where you promised to do or not do something? If the answer is yes, then you consented to wear an obligor mask. That's a contract. Whenever there's a contract, you're consenting to do something or not do something. The statutory child support courts have subject matter jurisdiction over domestic relation issues, and this includes the definitions section of the Uniform Family Support Act. This is where they assign civil statuses, is in that definition section. And those are so we're going to challenge that. That's the fact and issue we're going to challenge. By accepting the definition section of UIFSA, Uniform Interstate Family Support Act, you agree to act in that person status of an obligor. It's also an artificial person. Obligor person is an issue of fact, as I just said. You cannot make a special appearance if you have appeared several times. I get this email all the time. Rick, I want to make a special appearance. And one of my first questions will be, well, how old is the case? Well, it's 5 years old. It's too late. Okay? So you can't make a special appearance if you've already been in court. Now, maybe if you've been to court one time, you can withdraw your appearance. But that's another issue. Okay? Now, again, I said this before, general appearance is when you submit to the court and it has jurisdiction over your person. Civil status. Appearing without objecting to obligor person, civil status, is consenting to act in that mask. Also, you accept the obligations and duties. Basically the same thing. Obligation is a duty, including the rights and obligations. I just said that. See? If you unknowingly appear generally, the next course of action is challenging the issues of fact. So these courts, they're challenging issues of fact. They're issues of fact courts. It's all it's about. It's about facts. Okay? And as I said, where do the facts come from? It has to come from the facts existing at the time the jurisdiction is invoked, and the jurisdiction only depends on the facts existing at the time of commencement of the suit as they appear from the complaint or other original pleading of the plaintiff. The plaintiff has the claims, makes the claims, and has to prove them. And again, most times we don't challenge the facts. A lot of people, I'm challenging the jurisdiction of the court. And again, that's not a bad thing, but which jurisdiction are you challenging? Okay, is it subject matter jurisdiction? Or is it personal jurisdiction? So when one of these fake judges, these magistrate judges, friend of the court, these people, they hear that, they automatically know you don't know what you're talking about. And they just shoo you away and just speak all over you. Okay? So when issues of facts or facts in issue, you present the challenge that the presumed facts must be established or proven by the fact finder. Who is the fact finder? The fact finder is the judge of the court or the tribunal. Now, here's another trick they do. If a lot of times certain jurisdictions, certain states, they have actual judges. But what you don't know is that they're not acting judicially in that role. They're really acting ministerially. Okay, they're actually acting as a fact finder. Okay, so they're a fact finder. It's issues of fact. The whole thing's about issues of fact. So, and it has to be, what do they call it? Probandum. I'll show you. If you do not object to the issues of fact or facts in issue, they become facts by your silence. You consent. Okay? How does the state assign civil status, rights, and obligations? They, the legislature, must create a civil statute that imposes and enforces a result they want. This is done by imposing civil obligations against one party and rights to the party those obligations are owed. Rights and obligations always come in pairs and always involve two or more separate parties or fictions. The fictional person with the obligation is called the obligor. The fictional person to whom the obligation is owed is called the obligee. Okay, now this is a typical definition from this is from New York, but they're all the same. Okay, so under the Uniform Interstate Family Support Act. So obligee means an individual to whom a duty of support. So it's like it's already a conclusive statement. They're owed a duty of support. So when you accept this definition, that means you owe the obligee is due a duty of support. That's why we have to object to this and challenge this fact and issue. Is or is alleged, and I just throw that in there, to be owed or in whose favor support order or a judgment determining parentage, blah, 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 blah. I'm not going to read all of this. But again, this is basically a status. So this is usually the mother or the child support agency acting on behalf of OBO. You'll see that on behalf of the child or children. Okay, and an obligor means an individual or an estate of I'm not going to read all of this, but again, this will give you the idea. It's a conclusive statement. Okay, is a debtor. So we're going to challenge it. So how can you challenge civil statuses? Answer: a motion, issue of fact. What is a motion challenging the issue of facts? Answer: according to 56 American jurisprudence, 2D, motions, rules, and orders, section 24, an issue of fact is an issue of facts on a motion is a question for the court where the allegations of the motion papers are controverted, challenged. Thus, raising an issue of fact, the moving party has the burden of sustaining his allegations by sufficient proof, and if he does so, the responding party has the burden of overcoming the competent evidence. You just challenge the facts, and I provide that with my paperwork that I have for the states, and it's recently somebody filed it, and this shows you how these courts operate. The judge basically what she did was, she was like didn't want to answer it on the record, and then what they did very sneakily is they mailed, this was on a Friday, they held the motion hearing on the Monday, but he didn't receive until Wednesday. So obviously he defaulted because he didn't show up. So how can they expect him to receive it? They mailed it on a Friday after he left. It was just their way of saying, oh well, we sent it to him, because it's a violation of due process if he's not notified. So he receives it in the mail. And then the whole thing to do now is you got to go and fight it and show that, I didn't show up. I defaulted because I didn't receive it. Look, it showed up in the mail. But that just shows you, why would they schedule it on a Monday when he leaves the court on Friday? Because they know they can't answer the facts and issue. Okay? It's a nice little tool. Okay? So, and again, what's a issue of fact and a fact and issue? This is the Black's Law Dictionary. A fact that one party alleges and the other controverts. A fact to be determined by the Factfinder, probandum, Latin. Also written fact and issue. A fact and issue is a fact as to the correctness of which the tribunal under which the case must be persuaded. So remember, we talked about over here, okay, the facts existing at the time jurisdiction is invoked. So these facts in the complaint and pleading are being used to persuade the court why the cause of action by the plaintiff should be in their favor. Okay? So the term probandum is a thing to be proved. So it's a fact that needs to be proved. So, this is a nice little tool. And I found this going through the books of the American jurisprudence book. And this guy was like the first guy to use it. And it was a nice little response, even though it was underhanded. Okay, but it shows that they can't answer these facts. They don't want to answer these facts because they can't. And most people don't use this tool, this motion. Okay, and what happens if they can't substantiate or establish the facts with evidence? What happens is the case should be dismissed involuntarily because there's no facts. Okay, that's an issue for another day. All right, so listen, hopefully I'll see you guys soon. I always say this all the time, but okay, so this is only 21 minutes. And again, if you wish to reach me, right here. Okay, all right, guys, enjoy your Memorial Day weekend. Bye.